is the evidence that was adduced at the trial and the basis for conviction. The other aspect and factor that the court will take into account that makes this stage to be a critical stage of the trial is the nature of the offense. So the court will have to go back and look at what is the offense that the accused person is charged with. And again, in addition, the court will have to take into account the circumstance of the case. And each case is treated on its own unique circumstances. Why are these factors important? Because at the end of the day, the question that the court must ask and answer is whether the sentence that this court will mete out in this matter today is the appropriate sentence. And more so, whether it meets the interest of justice. Please have a further reading. The case of Anton Paraido versus the State of Mahindra is an Indian case and speaks again to the importance of the process we are in today. And it says that sentencing is an important task in the matter of crime. And again, the reasoning for that is that at the end of the day, the court has to decide an appropriate, adequate, just, proportionate when the death sentence may be inevitable. Let's look at Article 4 of the Africa Charter on Human Rights, on Human and People's Rights, ratified on 23rd of January 1992. It provides that human beings are inviolable. Every human being shall be entitled to respect for his life. His, in my considered opinion, includes her life, and the integrity of his or her person. Again, it reiterates, no one may be arbitrarily deprived of this right. Muratetu reflected again. The Supreme Court says that you can indeed what the evidence said. And the first thing that was revealed by the evidence is the manner in which the offense was committed. I want to remind ourselves of the judgment I delivered on 9th of February, where I indicated clearly that the evidence of the doctor who conducted the post-mortem report indicated that the person who perpetrated this offense cut the throat of the deceased through and through. In that judgment, I spoke to an understanding that the person was not an amateur. The person must have had some training. And remember, the evidence even revealed that after the offense was committed, the deceased was put in the bathtub and the shower tap was put over to run the blood off. When I read the report presented by the probation department, where the accused person himself says, I have been trained by the Dubai Police Academy and an Ogara group, I thought that corroborated the finding of this court that there was full scale for commission of the offense. I do recall saying in that judgment that the manner in which the offense was committed did not at any time intend to give the deceased one more minute to live. I do recall throughout the trial, no any other than the counsel representing the accused person in this trial throughout kept on referring to the incident and the scene of crime as a slaughterhouse. Secondly, we have had the benefit of looking at the photographs showing the body of the deceased and the injuries. I would certainly not display them there, certainly not, at least for the benefit of the family. And I did indicate in my judgment, no one would like to look at them again. Not once, not twice. Now let's look at, and this is very critical, because it is not the court just making an observation, it was a brutal murder. Let's look at how the defense, that is the submissions in mitigation by the accused person himself, describes the offense. I will now read to you how they describe the offense verbatimly. They say that it is a tragic, curious loss of life on extreme circumstances bordering on an act of absolute madness that is beyond understanding. So even the defense joins the victim's family and the prosecution and the court in arriving at the conclusion it was a gruesome murder. Horrific, frightening. Let's now look at another important aspect that the court has considered. The consequences of the offense. From where I sit as a court, each one of us is responsible for the natural and the probable consequences of our actions and or omission. So it's not just an issue of committing an offense, but the far-reaching consequences of that offense cannot be ignored. And so in this case, it is undisputed that the deceased was the managing director of the family's business in South Sudan. It is undisputed that the business collapsed after her demise. It is undisputed that that was the source of income for the family, and we can all appreciate the natural and probable consequences of that. I have already made reference to the fact that the other consequence of this offense is what has been described, and unless there is evidence to the contrary, I believed it because it's in the probation officer's report, that the mother of the deceased suffered depression and stroke, and she has hardly healed. I've spoken to what the brother is said to be undergoing. This court, and I never lose out on anything, I try to get as much of in-depth of the material before me as I can, has been invited to take cognizance of the fact that the father of the deceased at one time said, I will let go. That did not form part of my record, because what formed part of the court's record is his sentiments as expressed in the Brigade report, and that is what I will safely go by. But I'll be concluding with one or two other findings that could probably remove us from that mind thought that the father said, do not, vengeance is not mine. I also want us to just, in concluding, other than looking at the manner in which the offense was committed and the consequence or the impact of the offense, I took a bit of time to look at the character of the accused person. I have already spoken to how the probation officer describes him: aggressive, antisocial personality, and concludes he has double personality traits. But let's look at what else this court was able to gather while hearing this matter on the character of the accused person. It was the evidence of the guards at Royal Park Estate, where he was staying, that he would not allow himself to be searched. He would brandish a gun and say, "I work at State House." Just rival. He was still involved. I'm not condemning him because there's no charge before me. But the court cannot avoid looking at this. Because at the end of the day, the question is this: is this a person you want to release back to the society? And these issues become extremely critical for consideration. Finally, this matter and the evidence adduced does not lead to a conclusion that this murder was accidental. That the perpetrator did not have an opportunity to think about the consequences of his action. It was intentional. It was not a defensive act. It was not out of provocation. It was planned. It was intended, and it was executed. And those who do not subscribe to Christian faith, bear with me. I do, and that's the only place I could make reference to. In the book of Job, chapter 1, verse 12 to 13, this is what is written. I think I looked at the, was it NIV? You can find out, speaks to the same thing. This is what the Lord said to Satan: "Behold, all that he has is yours. Only do not lay a hand on his person." I'll repeat. Behold, all that he has is yours and is in your power. Only do not lay your hand on his person. The provision of life is the preserve of God. And I find no room anywhere for a person to take another person's life unlawfully. In my very final conclusion, join me in listening to these wise sayings on murder. 1. In the act of murder, one person's life ends, but countless number of lives are forever impacted. I will read again. In an act of murder, one person's life ends, but a countless number of lives are forever impacted. Secondly, murder leaves behind a trail of shattered dreams and broken hearts that can never be healed. Murder leaves behind a trail of shattered dreams and broken hearts that can never be healed. I have said the accused person before me is 33 years. The deceased was 28 years. Thirdly, the act of murder is a heinous crime that challenges the moral fabric of society and demands justice. And so it is not just a loss to the immediate family. Of course it is in the highest degree, but it's a loss to the society when one is killed unlawfully. And so, based on everything I have said, I have ordered that the first accused person before this court being Joseph Irungu alias Jowie, shall suffer death as provided for the offense of murder under section 204 of the Penal Code of Kenya. And that sentence is lawfully set aside by a court of competent jurisdiction. That is the order of the court. Thank you.